My name is Josh Capel. I'm one of the founding partners at Vicente, and really excited to have this webinar today. Our sort of goal, yeah, and really our goal is to like provide the information you need. So, and we'll talk a little bit about the agenda, but thank you all for coming. Next slide, please. Like all legal webinars, this isn't here to give you legal advice. Just because you join our webinar doesn't mean you're our clients. We do work with a lot of clients in the psychedelic space, but this webinar is really about providing educational information and trying to get good information out there about Colorado's new natural medicine program. Next slide, please. And yeah, as I mentioned, Vicente, we work with a lot of people in the psychedelic ecosystem, from legacy practitioners to those who want to apply for a license in Colorado, to physicians, to tech companies, really, across the ecosystem, we're there to help you. We have offices, across the country. So if you want specific legal advice, feel free to reach out. Next slide, please. And yeah, I'm really excited today. We have, Barina, who's, the co-lead of the psychedelics practice with me at the firm. Absolute great attorney, very, very thoughtful on a lot of these ethical issues. I'm excited to have her. Jericho is one of my partners. Worked with Jericho forever. Again, also an amazing attorney. She leads our licensing department, and she's going to do, a presentation around, hey, what does it mean to be licensed as natural medicine businesses, and what are some key considerations? Next slide. And so, quick agenda. I'm going to just give you a quick overview of where we are with the Natural Medicine Health Act. Jericho, as I alluded to, is going to jump in with an overview on licensing. And then we're going to try and spend as much time on questions and answers as possible. And thank you for everyone who sent us questions. We're going to try and, move through them in an efficient manner. A lot of the questions are very complicated. But we're going to do our best for you. And if you have questions that come up, or if you have burning questions that you've been sitting with, feel free to post those in the Q&A function. And hopefully we can get to those too. But again, sort of this webinar, our sort of intention here is like how to, how can we create a presentation that's like helpful for you? So next slide. All right, where are we? Yeah, so the Natural Medicine Health Act by the numbers. So big pieces, we're done with rulemaking. There's no active rulemaking going on right now, which has been really the first time in like at least 10 months since we haven't had active rulemaking. There's really been like 6 sets of regulations adopted. DORA has gone through four rulemaking processes. Their latest regulations were adopted, about a week ago, and they're not going to become effective, for another 45 days. But you can find DORA's other 3 set of regulations on their website, and then there's this 4th piece that that discusses at-home locations or discusses really where natural medicine services can take place outside of a healing center, which includes a participant's home in certain circumstances, and also healthcare facilities. Big win there. DOR has adopted their set of regulations. They're on their website. Those are finalized in September. And then for those who are really interested in testing, CDPHE has also adopted regulations around testing. So there's 6 sets of regulations. And overall, very proud of where we landed, with the regulated program. Really thanks to a lot of people who participated in the rulemaking process. We really landed, in my opinion, in a really good spot, really building off of Oregon and others. There's 13 training programs that have been approved, and there's, hundreds of students that are being trained as facilitators now. You can see the list of approved training programs on DORA's website. There's been 11 healing center applications submitted, 3 of those micro healing centers, 6 cultivation applications, 1 of those micro, 2 products manufacturer applications, one testing facility application. None of those have been approved yet, but people are applying, and and we'll hear from Jarek about what does it take for you to apply. And there is a bill pending in the state legislature that wants to restrict chocolates and gummies and other products in the regulated space. So this is Senate Bill 25076. If you want to get involved, please contact your elected official, about this piece of legislation, or feel free to reach out to us. And then the last piece is, Dora has been doing a really good job in trying to get information out to the public, and they have 9 different educational flyers on their website covering a range of topics. So for questions we might not answer, please feel free to check out their website there. So that's where I'm at with the Natural Medicine Health Act. By the numbers, the program is live, applications are live for facilitators, for natural medicine businesses. Rulemaking's done. There's still potentially some statutory changes, but all things are a go. So with that, I'll turn things over to you, Jerica.
Thanks, Josh. So like Josh said, I'm just going to give you a very quick overview to inform the question and answer conversation we are going to have, which will be the bulk of this presentation. Again, we wanted to have, instead of just talking at you, we wanted to sort of collaborate with you and answer as many of your questions as we could, so we're getting helpful information for you. Generally, what we'll be talking about today is natural medicine business licensing, but in addition to that, we'll also be talking a little bit about personal use. There's a lot of those questions in here, facilitator licensing, and actually holding administrative sessions, whether that be in a private residence or at a healing center. And I think a couple of questions mixed in here about these other facility types too. So the natural medicine businesses we do have that are currently being licensed here in Colorado, like Josh said, are the healing center. That includes a micro healing center. You can do one or the other. A cultivation facility. There's also the micro cultivation facility. You can do one or the other. Manufacturing facility with or without the extraction endorsement, and of course, testing facilities. Next slide. So this is just an overview of the fees. We get a lot of questions about fees, so we wanted to provide this information to you here. This is just year 1. Fees do increase in year 2, and they have released those as well. So if you do need those, let us know. But this gives you an idea of the cost for the application fee and the license fee. Application fees due at the time of application. License fee will be prior to license issuance. So prior to you getting that final go-ahead to begin operations after you've submitted your application and it's been reviewed. Next slide. Okay, so let's talk a little bit about the application requirements applicable to all natural medicine businesses. Number one, and something that can take the longest, is having a properly zoned property. So whether you're doing healing center, micro or regular, cultivation facility, micro or regular, or you're going to be a manufacturer, you do have to have a properly zoned property, and you have to demonstrate to the enforcement division that you actually comply with local zoning. We'll talk a little bit about what that looks like and how to move through that process here in a bit. That's number one. And then number 2 is all your corporate documentation. You do have to apply as an entity for a natural medicine business. You can't apply as an individual. And we do have some folks who were hoping to apply as an individual, but you do have to actually register an entity with the Secretary of State, set that up, and then you can apply for your license with that entity. You'll have to go through the criminal background check as part of your owner application. And then, of course, if you have a financial interest potentially as well, financial interest disclosures. As you all probably know, or maybe if you don't, you can only have a financial interest in 5 natural medicine business licenses. That's the purpose of this, to make sure no one's violating that. Your ESG plan, we'll talk a little bit about what that may look like. The division's given actually quite a bit of good guidance on that, and some operating plans as well. Operating plans, security plans, those are required. You're not required to submit those, though, until you're ready to begin operations. You don't necessarily have to submit those with your application. Next slide. So local governments, like I said, a properly zoned property is the number one thing that can take the most time, and we're seeing people struggle with, that you do have to obtain a natural medicine business license. To apply for a license, you do have to have a property. I believe we did have one question in the chat. I'll go ahead and answer that one already on whether or not local governments can actually ban these types of businesses, whether they be healing centers, cultivation, or manufacturing. They cannot. They cannot ban. They can't enact moratoriums. They can, however, regulate these facilities by regulating time, place, and manner, right? So that's what we're seeing is zoning, for example, or Denver, who for some healing centers and the other businesses, natural medicine businesses, will be requiring an actual local license, right? We're seeing that as well. We're nothing like competitive lottery licensing that we saw with other industries like marijuana, and no bans like we saw with marijuana. Now, some localities are silent and deciding not to enact or have not yet enacted an ordinance applicable to natural medicine businesses. We'll talk a little bit about what that looks like here in just a bit. There's multiple approaches that localities and counties are taking. So it's not just towns, the counties can regulate as well. There are some restrictive localities like Parker and Colorado Springs, as you can imagine. Some that are quite reasonable: Boulder, Arapahoe County, Jefferson County. For example, Jefferson County actually doesn't have an zoning ordinance specific to natural medicine businesses. It's a very easy approval process there. And then wait and see, which is what Lakewood is doing. They're not enacting anything right now, but it does seem like they intend to down the line. And then, of course, any ordinance a locality or a county enacts can't conflict with state law. Next slide. So property compliance. You do need local government zoning approval. And then in addition to that, we do have the state setback requirement of 1,000 feet from schools and daycares. This can be waived by local governments. Boulder, for example, did actually, we'll call it waive this requirement. You'll need a map as part of your application for a healing center that demonstrates you meet this 1,000 feet setback requirement. It doesn't need to be prepared by a licensed surveyor or anything like that. You know, you can use Google Maps. The rules actually do indicate how that measurement needs to be taken. We can assist with preparing that map, but that's an easy requirement to meet as far as setbacks. You can have explicit or implicit local government approval. For example, Jefferson County, I think, is a good example. They're not issuing, you're not required to have a zoning verification letter from them. You can apply for one and they will give you one for $150, assuming you meet their very generous zoning requirements. Sorry, I just forgot my train of thought. I apologize. But you can have one. So there is implicit or explicit local government approval in some, depending on where you're locating. Many communities do have zoning ordinances in progress that they haven't finalized yet. So if you are planning to locate there, it may make sense to wait until those ordinances are finalized. And you know that your property is in fact going to comply with zoning requirements. Jefferson County, we just talked about with their informal guidance. And then some communities do have moratoriums, but they cannot ban long-term. And then some communities are applying their existing zoning code, right? Again, they're not having specific natural medicine business zoning. They're just applying. Jefferson County, I still think, is a good example of this. So for general medical office use, right, for healing centers, general agricultural for cultivation, and so on and so forth. If you currently have an office or a property, for example, you know, if you're currently practicing out of your medical office, you will have to show that that is properly zoned. In most cases, in most localities, it likely is if you are at a medical office. Next slide. So corporate and other required information, this is not all inclusive, but this gives you a general idea of the documentation you're required to supply with your natural medicine business application. This is not specific to your owner application or an owner entity application, although those do include some of this as well. But your formation documents, corporate documents like your operating agreement, bylaws, if you're a corporation, any sort of promissory note, whether it be secured or unsecured or other loan agreements. This again is to determine and verify that nobody has more than five financial interests in licensed businesses. Contracts entitling anyone to any portion of the revenue of the licensed business, that would automatically give them a financial interest. And then personal information for anyone with a financial interest or any of these other agreements. And then, of course, site control. So you will apply a lease or a deed with your application for business. Next slide. This is guidance on your ESG plan, which the department has actually issued a guidance document for your ESG plan. That's environmental social governance plan. You can choose at least one of these. This is not an exhaustive list, so you can choose to provide additional avenues to satisfy this. It is publicly available once you submit and are approved, and they will be checking your progress each renewal period. So every time you're required to renew your business license, they will look at this and they will require you to update them on your progress. So this certainly isn't something that's intended for you to submit and then forget about. In order to obtain renewal of your license, you'll need to demonstrate progress on your ESG plan. Next slide. Okay, let's move right into our Q&As. I'm going to answer a few that were specific to healing centers we already received, and then we'll move into the other. I think we already have 50 or so we'll try and move through these as fast as possible. So how to start a psychedelic business? We kind of just went through this. Here in Colorado, you need to set up your corporate entity, register with the Secretary of State. Depending on how many members you have, if it's a single member LLC, you may or may not need an operating agreement. We would always advise that you do have those corporate governance documents. You'll need to think about insurance. While it's not necessarily required, it's something that you should be aware of, right? And then submitting that application with the state to get your license, which would require you to find a property. Again, you cannot obtain a license without a property, and then obtain local zoning approval or demonstrate that if you can. And then, of course, before you begin operations, let's say you're a healing center, for example, you would have to contract with a facilitator in order to actually begin operations at your facility. Or if you are an owner facilitator, of course, you can move forward that way. But that's how you would, those are the very basics on how you would start a business. There's a lot more that goes into it than that, though. I understand. So question 2, I understand that some localities are more hospitable than others regarding natural medicine businesses. Do we have a temperature on each? So yes, our firm is keeping a locality tracker that includes counties and localities and where they are in the process of enacting ordinances or discussing them. We're tracking minutes, meetings, agendas, things like that for our clients. We are always happy to share that information. If you're engaged with us, we're sharing some of that information on this call. But yes, there's some pretty extensive tracking that's gone into that. Unfortunately, the state doesn't have a resource that shares that information. It would be great if they did, but right now they don't have that capability. Jefferson County, I know someone asked about that. They are friendly to businesses. There's no natural medicine specific zoning ordinances. Broomfield, I don't believe Broomfield has enacted anything. Generally, Broomfield, as a community, it has been fairly strict with other industries. So I expect we will see the same here. Josh, I don't know if you have any other information specifically on Broomfield.
I do not on Broomfield.
But we're happy to look into any locality or let you know if we already have the information for that locality or county. Can municipalities ban? No, they cannot. They can't ban any type of facility. Can a microhealing be established inside a private residence in Arapahoe County? So Arapahoe County has actually zoned healing centers as medical use. That means it's unlikely you are going to find a private residence that's zoned appropriately for medical use, but it is possible. It certainly is possible. So you would want to look into what your private residence is zoned as, determine that it's 1,000 feet from a school or daycare. And it's possible, though I would say it is unlikely.
Yeah, and I guess just to add on that, Jericho, for those who are wondering if hey, does this location, comply? First step is just search the counties or the city's website and see if they have a natural medicine ordinance. And then you can also like call the zoning clerk and see if your office applies or if they're talking about it, or you can call us and we can help you do all of this. But I think the first step is like to do that research to see if that like specific location applies. And private residences, there's like a number of reasons why you wouldn't want a healing center license there. But if it was a large enough space where you had, maybe a separate building on the private residence, like maybe it does make sense. And there's like rumors that some rural communities are allowing that, but we haven't fully, verified that. So thanks for letting me interrupt, Jericho.
Thanks, Josh. No, thank you for doing so. How many people are allowed to band together to create a micro healing center to share the cost of licensure? There's no limit on the number of owners that you have or the number of people you're taking loans from that have a financial interest. Really, the only limit is one person can't have more than 5 financial interest in licensed or in 5 licensed businesses, right? So you could have 20 people that band together and each have a portion of ownership in a healing center license or a cultivation facility or manufacturing facility license. For micro healing centers, what kind of security or surveillance is necessary? So for a micro healing center, you're just going to need a locked space where medicine is stored, a locked and secured space, and surveillance on that locked and secured space while natural medicine is being stored there. So the security and surveillance requirements are much less burdensome than they are for a regular healing center. Really, if you can, I think what the department actually has posted on their website, if you can show that you're 1,000 feet from a school and show that you can lock your door at the end of the day and safely store medicine, you're good to go. I don't think it's quite that easy, but it is intended to be quite a bit easier than a regular healing center. Does the no people under 21 allowed on the premises part of the law stand? So you can't have people under 21 in an administration area when an administration session is being held. So no, it is not a premises-wide ban on individuals under 21. Moving on to some other questions. If I'm applying for a facilitator's license, do I need to have a healing center in mind where I plan to hang my license?
Josh, are you shaking your head?
Hmm?
Are you shaking your head?
I mean, if you're applying for a facilitator license, do you have to have a healing center license in mind? No, you don't. You can just become a facilitator, but you have to practice associated with the healing center. So
Yeah.
if you want to practice natural medicine services or practice facilitation, you have to do so affiliated with the healing center, but you don't need a healing center to apply.
Yeah, thanks for clarifying. I was alarmed that you were shaking your head. Yeah, you don't need a they're not going to ask who's your healing center that you've joined up with, but practically speaking, you either have to do sessions at a healing center or you have to, in the limited instances where you cannot have a session at a healing center, you still have to be an owner of, an employee of, or an independent contractor of a healing center. So practically speaking, you're going to have that affiliation.
Yeah, and just to double click on that for a second, so the latest DORA rules that were adopted, allow for natural medicine services to take place outside of a healing center, provided that the participant is receiving palliative care, hospice, is disabled or homebound. And it can take place either at the participant's home or it can take place at a healthcare facility. But for the facilitator to go provide those services, they have to be affiliated with the healing center, as Barina mentioned. And in fact, they also have to have 50 hours of experience providing natural medicine services at a healing center, or they have to have a palliative care or hospice certificate before they provide those services as well. So there are specific requirements, around providing services outside of a healing center, but you still have to be affiliated.
And guys, just because this question comes up a lot, and I know a lot of our clients and probably a lot of folks on this webinar are really good nerdy types who like to go read the rules. This is in the adopted rules that were adopted by DORA on February 7th. So you can find that on the website. It's not in the original rules or the previously adopted rules. It's like an additional section of rules that were adopted on February 7th, and 6.18 is what you want to read. And if you guys were involved in the hearings, you heard a lot of us in the community talking about rule 6.18. But that's where all of the details of this are spelled out, because I know there's a lot of questions about it.
So I think this is a great segue into the next question. Can I, and I assume when they say I, they mean a facilitator, only practice at a healing center or micro healing center? What are the exceptions for this?
I think Josh hit that pretty well to summarize. Yeah, again, it's in 6.18. It's hospice, homebound. Let me pull up the list. It's hospice, homebound,
Disabled under
has a
the ADA.
disability. Yep. Palliative care services, and then there's some definition about what palliative care means. There's basically these 4 exceptions in which you can, and then there's additional restrictions about what you as a facilitator have to have. You as a facilitator, a clinical facilitator has to have to be able to do that, which is have this relationship with a healing center, and additionally have already done 50 hours of admin sessions or actually be certified in palliative or hospice care. Oh, and actually, I know this is a question that will come up later, but maybe we can address it here. Someone asked if I can provide, if I can do administration sessions outside of a healing center, which only applies in these limited cases, how do I get the medicine there? You would also have to hold a handler license and handle the medicine in appropriate storage and transport in accordance with the normal storage and transportation regulations for moving regulated medicine around. But you as a facilitator, if you were going to practice outside of a healing center and you were allowed to with these restrictions, you'd also have to have a handler license yourself.
Do I have to have more than one present to or film the session? Is the other person required to be a facilitator or facilitator in training?
So is that, Jericho, is that related to the outside of a healing center question or just freestanding?
Just freestanding.
So if you're in a healing center, you have to offer the participant the option of having it recorded or having an additional facilitator there. And I think you have to comply with their wishes there. And you can't hold a session outside of a healing center if you're not willing to either record or have an additional facilitator there. And I think if a participant in a healing, I think the participant can also request that they have a non-facilitator present, like a second non-facilitator person present, but I don't think you have to agree to that provision. It's only that you have to comply with their wishes to video record or have an additional facilitator. Josh, is that right?
Yeah, so for the homebound piece, it has to be one or the other. You have to have either 2 facilitators or a recording, period. And there's no group sessions allowed.
And if the participant, I'm sorry, and if the participant doesn't want that, I'm sorry, I misspoke. So if the
yeah,
participant
if the participant doesn't want
that,
it, then you can't do it. And
then
then at a healing center, there's more flexibility. You know, there's like a facilitator can have group sessions, but isn't required to, can have other people there, but isn't required to. And it's sort of like a mutual consent by both parties. You know, so if the participant wants something the facilitator is not comfortable with, they need to refer the participant out. And vice versa. So, you know, it's like there is like some flexibility. The ratio sort of requirements under the rules are 1 to 4 for facilitators, 1 facilitator to 4 participants if the dosage is over 2 milligrams of total psilocin. If the dosage is under 2 milligrams of total psilocin, then the ratio is 1 to 8. And that's also part of the recently adopted DORA rules.
If I don't have to facilitate at a healing center, how do I get the medicine to the client?
I think that's the one we addressed earlier. In the limited cases where you can facilitate a session outside of a healing center, you would have to have a handler license.
Are there considerations for rural areas? And I'm not sure if this is specific to a type of consideration. So perhaps if you put this one in the chat, you can kind of specify what you mean there. We can come back to it. I'm looking for clarification about who can provide consultation and what counts as consultation. I've heard that the consultation hours have to be after obtaining a training license. However, they've also been told by some participants in a program that they were able to apply for full licensure right away with consultation somehow being counted within their program.
Yeah, so, you know, there's a lot of different pathways to licensure. And, you know, but the main one is, you know, for someone, you know, they need 150 hours of didactic, then they need 40 hours of practicum, and then they need 40 hours of consultation. And after the 150 hours of didactic, and there's a couple exceptions, you can apply for the training license. And in many cases, you'll need to have a training license to engage in the practicum and the consultation hours. After you finish the practicum, you're actually allowed to practice and get paid for providing natural medicine services under the training license, provided you're engaged in the consultation process with a consultant. The consultant definition is an individual has 200 hours of experience providing or facilitating with psilocybin. It's specific, and it's on the duty of the applicant to sort of like prove that the person who they're consulting with meets these requirements. And so that's sort of like the traditional pathway. And there are some exceptions. If you're licensed in Oregon, you have equivalent education or experience, where in some cases you might be able to skip some of those steps.
Thank you for that. What are the criteria and ongoing requirements for psychedelic church status? And can you compare and contrast that a little bit with healing center?
I'll let Josh speak. I was going to say, I'll let Josh speak about the church because he's, our total expert on that. But I do want to say these two questions alarm me a little bit because there's no psychedelic church status under the Colorado regulations. And I think that's important to say. A psychedelic church is not the same type of thing as a healing center, right? We don't have psychedelic churches as something recognized by the DOR or DORA regulations. Sorry, Josh, I'll turn it over to you.
No, you're absolutely right. Like the protections under federal law with the Religious Freedom and Restoration Act is separate. And that's sort of like not covered by this presentation. There's a lot of really good guides out there. Shakuno is a really good guide on, RFRA and how that applies to individuals who have sincere religious beliefs, and like the church is the right container. And so there's that piece. And then what you have is what we have under Colorado's law, which is, a regulated access model, and also, this personal and community healing access model. And on the regulated model, there is, a prohibition against the practice of facilitation without a license. And this is a very hot topic that's like currently being debated by the Natural Medicine Advisory Board and the subcommittees. Like, what does this mean? What does the practice of facilitation without a license mean? However, there is a statutory exception for that, for those who are engaged in ceremonial, religious, or spiritual sessions for pretty much nonprofit activity that's not associated to a for-profit business or commercial activity. And sort of that exception was sort of like created in mind to like create an exception for these, potentially, sincere religious churches, so they're not being accused of facilitating without a license. So there is some interplay between the two, but this sort of like what qualifies as like a psychedelic church, is a complicated question that's like doesn't necessarily fall into this section. Now, there isn't anything that prohibits a psychedelic church from like obtaining a healing center license. Like nothing limits that from like a statutory perspective, and nothing sort of like limits the community use section or the personal use section from also providing additional protections to a church that might be using a sacrament as part of their sincere religious beliefs.
In the DOR document, there are several entities listed under the definition of owner. One of them is the interest of a member in a cooperative or in a limited cooperative association. What are the practical limitations of a group of facilitators forming a limited cooperative association to own a micro-healing center? For example, could a facilitator in Summit County be a part owner of a limited cooperative association located in Douglas County to offer services to a palliative care patient in Summit County? Can you guys hear me? I can't tell if people are frozen.
I can hear you, Jericho. I think we may have lost Josh. I don't actually know the answer to this question. Yeah, go ahead.
So I think we talked about this a little earlier. Yes, multiple facilitators can join in to a multi-member cooperative to own a microhealing center license. Like we discussed earlier, there's no limit on the number of people that can hold ownership in a license. Really, this question I think is more pointed to what would the corporate structure look like and the implications of that corporate structure be for that type of organization, right? And that's sort of a tax question and an insurance question, but there's no practical limitations. Yes, you absolutely could set it up in any county in Colorado as far as like registering your entity and setting it up. And then, a healing center isn't who's going to provide palliative care at a resident, right? It would be a facilitator, right? But that facilitator could be an owner in this healing center organization and still go and provide services to patients that meet those 4 exceptions in anywhere in Colorado.
Thank you, Jericho. I think what's tripping me up about this question is like, what are the practical limitations of that? And I think you kind of hit that nicely. I think there could be tax or other sort of corporate structuring questions that we would want to think about. So this is definitely one that you'd want to get into with your attorney, your accountant, and kind of think through all the practical implications. But I think, yeah, as Jericho's saying, from a regulatory perspective, there isn't an issue.
As an LPC and solo private practice, what licenses would I need to add psilocybin-assisted psychotherapy to my practice? Would I need a clinical facilitator license and a microhealing center license? Are there any others?
Yeah, this is a really good question. And a lot of our clients and folks that we talk to are people who already hold secondary licenses and they're wanting to add psilocybin-assisted work to their practice. So the clearest route for you there would be to get a clinical facilitator license. You would be qualified to get one, and the steps are fairly straightforward. You would not need a microhealing center license or a healing center license. You would need to, as we talked about in the beginning, have some sort of work affiliation with a healing center or microhealing center. You could own one, so you could get a license. You could also be employed by one. You could be an independent contractor of one, but the bulk of your work would need to happen at a healing center or a microhealing center. And even if you fit those limited qualifications we talked about to perform administration sessions at an authorized location, you would still need to have that same relationship with a healing center, but you don't necessarily need a healing center or microhealing center license.
Yeah, and I think the question there is, do you want to hold them at your own office, administration sessions at your own office or not? And then let's say you did want to get licensed as a healing center. To do that at your office, you would need the clinical facilitator at healing center, and then you would also need to be licensed as a facilitator owner, assuming you owned that healing center license. So you would need to apply for that as well, but since you're already approved as a facilitator, it is a reduced fee, but it technically is a 3rd license you're required to have as an owner of a healing center. Can the client bring their own medicine to the session instead of me providing it?
No.
That's the easy one.
All regulated medicine. So it's all the medicine that's been cultivated, manufactured, labeled, tested, tracked, transported in accordance with the state regs.
Yeah, and so like and there's another question about this, like for cultivation facilities, but the natural medicine business system and regulated psilocybin, it's a closed loop system. If you're a licensed business, you can only, provide products to other licensed businesses. And if you're a facilitator, you can only use products that have been grown and tested through the regulated system. So, it is a closed loop system. You can't provide regulated natural medicine products to a church or to a community healing ceremony. It all needs to stay within the system, and there are specific rules around inventory tracking and transportation and sort of like tracking different transportation pieces as well.
Yeah, and I think that ties nicely back into a question Brina previously answered about how you would get medicine to a client if you were not holding session at a healing center. Again, it would have to come through the regulated system, whether that be through a cultivator or manufacturer. Like it does have to be produced by one of those types of facilities. The original draft rules have been saying that only whole mushrooms, whole or powdered and capsulized, could be used, but I've heard rumors that either extracted psilocybin, perhaps synthetic, might be allowed. Can you confirm?
So there is no synthetic psilocybin allowed. It's very clear, it's like psilocybin and psilocin, cannot be like created via any synthetic or semi-synthetic process. Manufacturing facilities are allowed to, so a cultivation facility, can create dried mushrooms, can sell dried mushrooms to a facilitator, to a healing center, or to a manufacturing facility. The manufacturing facility can then take the dried mushrooms and turn them into capsules or tea. And then if the manufacturing license has an extraction endorsement, they can then create chocolate bars, tinctures, or gummies. So there's a couple more items they can create, with an extraction license. There's limits on sort of like what, like the extraction rules are very limited. And so it's not really like extraction and like how you think of that term being used, but it is sort of like with this extraction endorsement, you can use ethanol, water, or food grade oils to like make additional products.
Will operating a second business as a personal use companion, for instance, offering sits in home or nature-based settings, jeopardize an LPC or licensed clinical facilitator license?
Yeah, or go for it, Verena.
I was going to say, it's an interesting question. My sense is that it's not clearly prohibited anywhere in the regulations, but that DORA would be very unhappy with you, is the sense that I've gotten, if you are both a license holder on the regulated side and want to practice under personal use. But I don't think it's black and white prohibited anywhere.
Yeah, so I mean, to provide like a little bit more nuance on this, if you're a licensed professional, whether that's a licensed facilitator or a licensed professional counselor or a psychiatrist or whoever it might be, like your license is protected if you engage in personal use, unless you're violating the standards of care or your standards of practice of that license. So what does that mean? So if you're a licensed professional counselor and you're giving away psilocybin products, quote, under personal use to one of your patients, like you're violating the standards of practice of being a licensed professional counselor, because licensed professional counselors aren't supposed to give their patients controlled substances, and it's very clear. And so like the same applies, like once you're a licensed facilitator, if you're working with unregulated products with your licensed facilitator hat on, there's definitely could be issues. Now, so then the question is like, hey, can you separate it out? And what does separating it out look like? And so that's like an open question. And a couple things, like nothing prohibits a facilitator from engaging in personal use. Like nothing says, hey, you became a licensed facilitator, now you can't use mushrooms at all. Like, no, like that's not what we're talking about here. Like there's actually protections around that. The question is the licensed facilitator violating their rules around being a licensed facilitator? And there's nothing that says they can't engage in personal use. And then there's also the question of whether someone's engaging in the practice of facilitation without a license. Are they providing prep sessions, administration sessions, integration sessions with psilocybin without a license? Or are they calling themselves a facilitator? And that's, its own separate question. So there's a lot of sort of nuances here, but there's nothing that clearly says if you're a licensed facilitator, you can't engage in personal use. And in fact, it actually says the opposite. But the question is like, by engaging in personal use, are you violating other laws? Potentially. It depends on like how you're engaging in personal use, and if you're using substances yourself, or if you're working one-on-one with a participant and providing all three steps. There's like a lot of nuance there that's like really worth unpacking.
Yeah, just to underline one thing Josh said, because this is a question I've talked to lots of folks about, and I just want to really, Josh alluded to this, but just to really emphasize it. If you are a licensed professional, any kind of licensed professional, and you are providing personal use services using unregulated medicine to your clients, you're definitely putting your license at risk, any kind of license. Those two need to be completely separate entities. So your therapy clients, for example, you can't also see them for personal use harm reduction services using unregulated medicine. They need to be a totally separate client base. Your entities need to be separate. And even if you do that, there are additional nuances that Josh was talking about that might not be clearly protected, or might not be clearly prohibited, but might raise some alarm bells for different regulators and things like that. But that first part is actually very clear. You can't be seeing your clients that you see as a licensed professional for personal use services.
When will it be legal to advertise using natural medicine as part of the description? And we've got a few questions about advertising, so I'll just ask the next one as well. Where do we stand right now regarding advertising this service on a business card, website, et cetera?
Yeah, so the biggest difference between sort of like the regulated program and the personal use program is that the regulated program is allowed to advertise, and there's rules around it, but they're allowed to advertise. On the personal use and community healing side, you're not allowed to advertise if you're getting paid for harm reduction or support services while sharing medicine. And it's a pretty blanket no advertising. And the state has the state agencies have publicly talked about how they believe most websites are a form of advertising. So it's something to note there. On the personal use side, if you advertise, it changes your conduct from legal to a felony. So it's pretty clear, and this has always been the law, that there's been no advertising on the personal use side. Now on the regulated program, which is does permit, advertising, and the sort of the purpose of that, and the purpose of advertising on the regulated program is hey, we create all these safeguards. We created all these rules so members of the public who don't have any access to the psychedelic community and hey, I need psychedelic healing I've been working with treatment-resistant depression for 30 years. I need someplace to go. I'm out of options. And they look and they can find, a healing center. They can find a facilitator on the regulated side, and advertising is permissible. Now there's restrictions on advertising. You can't advertise in a way that misappropriates an indigenous or federally recognized tribe. Or their traditional knowledge. You can't advertise in a way that appeals to minors. And then any advertising, you need to have proof that the audience that you're advertising to is more than, I think it's 71.6%. It's around 70% of that audience is over the age of 21. And a lot of times when you advertise in the Westward or really any sort of commercial advertising, there is very clear audience composition data. There's how they sell you on the advertising, but you have to make sure that it's over a certain percentage of those over the age of 21. And then there's a prohibit that you need pre-approval if you want to engage in sort of outdoor advertising, on a billboard, but there's an exception for businesses. Mm-hmm. So that's my long-winded answer on advertising.
It's a complicated question and issue. Have the required forms been finalized? Yes, they have. You can find them all on DOR and DORA's website. You can submit them online or in person. Okay, we're getting into some of the new questions. Can you visit Colorado and get treatment if you're not a resident?
Yes, you can. There's no residency requirement to become a participant. And on the forms piece, Jericho, there's a lot of forms that have been finalized. I'm not sure if they finalized the screening form or the informed consent document. I think there's still some, I believe the advisory board has made final recommendations around it, but I don't think those ones have been posted, but I could be wrong.
Thank you for clarifying that, Josh. Yes, I'm specifically referring to the natural medicine business owner, facilitator,
Yeah.
and handler forms.
All the application forms have been finalized.
Okay, is homebound only physical health related, or can it be mental health related?
I need to double check on sort of the definition of homebound in the rules. But one of the requirements or one of the potential options and the homebound question comes up if you're providing natural medicine services outside of a healing center, at the participant's home, or a healthcare facility, they have to either be homebound, receiving palliative care, in hospice, or disabled under the definition of the American with Disabilities Act. And I'm not entirely sure off the top of my head if the homebound includes mental disabilities. I want to say that it does, but I'm not entirely sure. But the fourth prong does. Bruna, you have an answer?
Yeah, I'm just looking at it right now. It actually doesn't distinguish, but the homebound certification needs to have happened by a physician, nurse practitioner, clinical nurse specialist, or physician assistant. So I think as long as one of those individuals was making the homebound certification, I think they could do that for Well, and it says need or needed skilled nursing care. So, I mean, I think, or physical or speech therapy, I think there probably are situations where a mental health condition could qualify, but the certification would need to come through one of the professionals that I mentioned, for example, not a psychotherapist.
Okay. Is there a requirement ratio of facilitators to clients for group works?
Yeah, and I mentioned this earlier. Outside of a healing center, it's 1-to-1 or 2-to-1. Like you have to have two facilitators to one client, or one facilitator to one participant. There's no group sessions. At a healing center, it's 1-to-4 for any dose. And then if the dosage where all participants are taking is less than 2 milligrams of total psilocin, then it can be 1-to-8. And calculation that is really kind of refers more to like potential psilocin in the product. And it's the amount of psilocybin times 0.719 plus the amount of psilocin. It equals this total psilocin number, for those who are nerdy on that issue.
I
And you
saw
can't
that.
have more than 64 participants in a group session.
Oh, yes, thank you, Brenda. I forgot about that one. Thank you.
I saw that the setback requirement around the 1,000 feet from schools or childcare centers is calculated by pedestrian access. Is this correct? There's a daycare next to me, but there's a fence separating us. You would have to walk around, which makes it over 1,000 feet. Is this okay? You are correct. It is by pedestrian access. And then in addition to that, it is from the nearest property line of the land used for the school or daycare. So it's property line to the nearest portion of the building that the healing center is located. So yes, if you had to go around the fence, that would be considered for pedestrian access, but you also need to make sure you're considering the other measurement requirements as well.
Yeah, and I guess like two pieces on that. Like depending on where you are, like in Denver, like you might be able to like pull a map or like ask, about this question. So some local governments like help you figure this out. And then, the fence, if the fence is the property line, like there's it's like it's not that they measure from the front door of the daycare, they measure from the property line, and that could actually be the fence. So they could be measuring it from the fence to like your property. So it is like a complicated question, and we highly recommend like specific legal counsel to like analyze your specific situation here.
Are there some places that group sessions are not allowed at healing centers? So I'm not sure if they mean like certain
Like a locality.
restriction.
Yeah, I mean, okay, so this is like a really interesting question, and some, and the second half of it's really interesting too. Are the rules about participants sleeping at the healing center? You know, there's there's not necessarily rules in state law that say like no, a participant can't sleep at a healing center. There's no like clear prohibition around that. Now, with local government zoning, depending on how it's zoned, there could be prohibitions on how many people can be, how many people can be in a group session, how many people can be at a facility at one time, can people stay the night, like especially with medical offices, there's different zoning restrictions and there's limitations on like how many people can stay the night. So in Denver, it's, I believe it's like you can have like 12 to 24 people can stay the night at a medical office zone property. Now, is that going to apply to healing centers? Like it's still to be seen, but there are specific like local zoning use standards that you need to be aware of. Specifically, if you're having like a home office, like a home healing center office, there's in almost every jurisdiction that has like home occupations, they say you can't have like more than this many people there at a time. So it's a very like local government zoning question. Remember, like local governments can regulate time, place, and manner. And so the number of people at a time is like a big manner question.
Can you have a single member LLC and then just contract with other facilitators? Yes, you can. You can contract with as many facilitators as you want, and they don't have to be owners of the LLC.
Correct. And I will say though, and we get this question a lot, it's like, hey, I want to open up a healing center. I want to rent out specific rooms to facilitators. Like, yes, possible. And also, like the healing center wants to be very careful because they'll be held liable for any regulatory violations of their facilitators. It's like making sure that there's like proper vetting, that the contractual relationship between the healing center and the facilitator is pretty clear, and who's responsible for what, and what are the SOPs of the healing center. Like, there's a lot of sort of work to be done in that sort of structure to make sure that like the risk is appropriately allocated and everyone stays compliant.
Does Dora have an approved list of consultants or supervisors, or will they?
No. Well, they might, but right now they don't. And our latest sort of conversations was they don't plan on it, like they don't plan on licensing consultants. But I think like this is all an iterative process, and this could change. So we'll see. For those who are like looking for a consultant, like making sure that the consultant is who they say they are and has met the requirements, and it's like very clearly met the requirements, are all like key pieces of that puzzle.
Can a facilitator, this is an interesting question, I've asked multiple times, so I'm going to ask it, but how about a facilitator that is licensed and is practicing in a harm reduction model, such as a client taking their own medicine and then the therapist is present to provide harm reduction support?
This is a very, very interesting question that doesn't have a clear answer right now. Like as we mentioned, like, the depth, like what is the difference between harm reduction and the practice of facilitation without a license are open questions, and Dora, and there has been a lot of like Dora informational sort of like investigations around this issue. So it's like something everyone's aware of, and there's not clearly an answer. There's also interesting questions around, sitting with someone while they take their own medicine, and, any sort of like implications there, both around like that, not licensed professionals, like what are their standards of care, what are their duties, what does their practice act say, and also what does their insurance say, so there's a lot of questions there that are like really unknown. And Verena, I'd love your thoughts on, I'd love your thoughts on this one as well.
Yeah, thanks. There's another one too that's related. Can a licensed facilitator provide services at a church as a sacrament, right? And these are all really interesting questions. And there's so many inflection points. Like, is it covered under personal use or not? It would be covered under personal use if you're sharing the medicine. If they're bringing their own medicine, presumably that's not necessarily personal use. I could make an argument that that isn't personal use, that's just harm reduction, but separate from the personal use protections provided by Senate Bill 23290. So there's really interesting questions there. But the one thing I would underline is, if you have a license, doing it with your clients that you see as a licensed professional is incredibly risky to you. More risky if you're a DEA prescriber, for example, if you hold a federal prescribing license, but still risky if you hold any other kind of license. So any amount of overlap between your license practice and what you're doing under personal use or something that might not even be personal use is very, very risky to you. So at a minimum, have those two separated and then talk to a lawyer about the nuances, because it's not totally clear.
And one more sort of like nuanced piece too is like there is, it's like physicians, for example, have always been able to like sort of like talk to their patients about the risks of using drugs, and there's like a Ninth Circuit court case about like physicians talking to their patients around cannabis. So there is like a lot of like protections for certain licensed professionals to like work with their patients, even if they're not as a licensed facilitator, but to discuss psychedelic use, both whether it's right for them, the risk, and potentially like, integration and follow-up care too. So there is like, it's not like, hey, you can't do this. It's just very complicated to like navigate it in a way that's not going to trip up other laws that are out there.
And can I throw in one other additional point of clarification? I know we're at time. There's one or two questions about ketamine in there. So none of this applies to ketamine, right? Ketamine is not one of the natural medicines approved under personal use or the regulated model. Ketamine is its own beast. It's scheduled differently, totally different creature than any of the medicines we're talking about here. I think worth emphasizing, because I think some folks think that it's all one big system, and it's not.
No, thanks for that. And there were a couple of questions about that. And we are out of time, guys. We're a little bit over. This was recorded. You should be receiving an email in the next few days where you can review the recording again. I know we had a ton of questions that we didn't get to. Maybe we'll do this again. Please do feel free to reach out with your questions, though. We're happy to discuss any of these issues with you. Appreciate everyone attending. Josh, Brina, any parting words?
Yeah, I mean, I think I'd just say like, hey, this is, very iterative process, and we're sort of like building this whole new field of psychedelic care in Colorado together, and we're doing it very differently than Oregon, and hopefully in a manner that's like more accessible and safer and more inclusive, and and we're all in it together, so thanks for those who are applying for licenses, and thanks for those who've been engaged in the process. It's really been an honor to be part of this process with everyone.
And thanks to everyone who showed up here because they want to do it correctly. I appreciate that. I think us being able to do this responsibly has a lot to do with how this will unfold for the state and for the country. So thank you guys for that.